She was not in the room when the will was read. That was not an accident. Her brother had made sure of it. He had scheduled the meeting with the estate attorney on a Thursday morning at 10 o'clock, during the one window of the week he knew she would be unreachable. He had told her the reading was the following Tuesday. He had done it calmly, with the kind of practiced ease that only comes from planning something for a long time. What he did not know, and would not know until months later, was that his mother had done her own planning, the kind that does not show up in a will at all. Their mother had built a modest life, but a deliberate one. She had worked for 31 years as an office administrator at a regional insurance company, saved carefully, bought a house in her mid-30s, and raised 2 children mostly on her own after their father left when they were young. She was not a woman who talked much about money. She was a woman who understood it, which is a different thing and an important distinction. She had grown up in a household where money was never discussed openly and always felt scarce, and she had decided early in her adult life that she was going to understand the systems around her well enough that no one could use them against her. She had kept that promise to herself quietly across 3 decades. She had a small shelf of personal finance books she had read cover to cover, not for self-improvement in any abstract sense, but for practical use. She had reviewed her own estate documents every few years, the way some people schedule a physical, because she believed that plans left unreviewed drifted away from their original intent. Her son had moved back into the house 6 years before she died. He framed it as devotion. He was there to help, he said, to manage her appointments, her bills, her correspondence. He drove her to doctor visits and spoke to her attorney and reviewed her financial accounts and reported back to her on the state of things. In the beginning, it had looked like care. Over time, it had begun to look like something else, though the shift was gradual enough that it was easy for anyone outside the house to miss. The accounts were consolidated. Her old financial advisor, a woman who had worked with her for 14 years, was replaced with someone the son had selected and arranged. Correspondence began arriving addressed to him in care of her rather than to her directly. Some of it she saw, some of it she did not. Her daughter lived 3 states away. She called twice a week, every week without exception, the same 2 days she had called since she first moved away at 22. She flew home for every holiday and for a few weekends throughout the year that had no occasion other than wanting to see her mother. She sent care packages in the winter and handwritten letters because her mother had always preferred them to texts. She had offered more than once over those 6 years to look more closely at her mother's finances, to ask questions about the arrangements her brother was managing. Her mother had told her each time to focus on her own life, that everything was taken care of. She had meant that in a way her daughter would not understand until much later. The relationship between the siblings had been difficult for years. It was the kind of slow erosion that happens in some families when one person positions themselves as the indispensable one, the one in the room, the one with the access, and the other person must choose between accepting that arrangement or creating conflict that lands near someone they love and do not want to wound. She had chosen acceptance. She had smiled at Christmas dinners and kept her voice even on calls and measured every conversation for what it was rather than what it might mean. She had paid attention. She had said less than she felt. 3 weeks after her mother passed, she received a voicemail from her brother saying that the estate had been processed and that some paperwork would be coming her way. He sounded composed. More composed, she thought, than the situation called for. The paperwork arrived 4 days later by certified mail. The will had been updated 14 months before her mother's death. It left the house and its contents to her brother, along with the remaining bank accounts, the personal property, and the investment portfolio. Her name appeared once in the entire document, in a clause that bequeathed her a specific piece of jewelry, a gold bracelet that had belonged to their grandmother. A bracelet. She sat with that for a long time, not because she needed the money, because she had built her own life and she was secure in it. What she sat with was the image of her mother, precise and deliberate, a woman who understood money better than almost anyone in her family, choosing to leave her daughter a single piece of jewelry. It did not feel like her mother. not the character of it. Her mother was not careless. Her mother did not do anything without thinking it through. She hired an attorney the following week, a general estate attorney first, someone who could help her understand what she was looking at before any decisions were made. They reviewed the updated will together. The revision had been made 14 months before her mother's death, during a period when her brother had exclusive management of her affairs, and when her mother had been recovering from a minor surgery whose recovery had involved temporary cognitive disorientation. The original will, drafted 9 years earlier, had contained an equal distribution clause. The new version did not. It was also noticeably shorter and written in a style that did not quite match the careful, specific language of her mother's other documented preferences. Her attorney requested a copy of the original will through the probate process. The contrast between the two documents was more than stylistic. The prior version had detailed provisions and even-handed language. The updated version had the look of a document produced quickly and reviewed minimally. Then the attorney found the trust. It had been established 8 years before her mother died, at a law firm in a city 2 hours away, separate from any attorney her brother had arranged. Her mother had gone there alone, by appointment, on a Thursday morning. The trust was a revocable living trust, properly executed and notarized. It named her daughter as the sole beneficiary. It held one primary asset, the house.
Her mother had retitled the house into the trust 6 years before she died. In the same month, her son had moved in. The timing was not a coincidence. It was a decision. The house had never appeared in the will her brother had used to conduct the estate reading because the house had not been part of the probate estate. It had been in a trust the entire time he was living in it, a trust he did not know existed. The will, the one he had arranged to have read on a Thursday morning without his sister present, had no authority over the house at all. He had been living in the property as its anticipated heir for 6 years. He had been managing it as its presumptive owner for the 14 months since their mother's death. He had pulled permits for renovation work. He had spoken to neighbors and to family members and to at least one realtor about the property's future, about improvements and plans in the market. He had been the steward of an asset that had never legally belonged to him, under a will that had no claim over it, while his mother's actual arrangement waited in a file at a law firm 2 hours away. The trust attorney had detailed instructions. She was not to make contact until the beneficiary came forward. That, too, had been a decision. Their mother had not wanted her daughter to be handed anything. She had wanted her to come looking, to ask the questions, to find her way to the file. When the daughter finally appeared in that office with her attorney, the trust counsel was ready. She had the documents. She had the transfer records. She had a notarized letter written entirely in their mother's voice and vocabulary, explaining her choices and the timeline of each one. Her daughter read that letter alone in a borrowed office on a Wednesday afternoon. She has not shared its contents in detail. She has said only that it answered every question she had been carrying, and a few she had not thought to ask. The legal challenge her brother mounted was predictable. He argued that the trust had been created under undue influence, or that their mother had lacked the cognitive capacity to understand what she was executing at the time of signing. It was the kind of argument that sounds plausible when you have no better one available. That argument was measured against the medical records from the year of execution, which showed no diagnosis relevant to cognitive capacity at the time of the trust signing. It was measured against the notarization records and the trust attorney's own contemporaneous notes from the client meetings. It was measured against the letter, written in a voice that was unmistakably their mother's, referencing specific conversations and observations that only someone fully present could have known. The argument did not prevail. It was not close. Her brother vacated the house on a date set by the court. He removed his belongings over the course of a single weekend. She did not arrange to be there. She had no interest in the theater of it. She did not sell the house. She kept it. She had it repainted in the first few months, a soft gray-green that her mother had mentioned wanting years ago on a Sunday call, offhandedly, in the way people mention things they have quietly wanted for a long time but keep deferring. The color is exactly right. Anyone who knew her mother would know it the moment they saw it.
She still wears the bracelet. She understands now why her mother left it to her specifically, in the will, in her name, in plain sight, while the real provision was held somewhere else entirely. The bracelet was not the consolation. The bracelet was the signal. A woman who understood systems, who had watched what was happening in her own home and had made her decisions accordingly, left her daughter something personal enough to be noticed and something quiet enough not to reveal the whole plan to the wrong person reading over her shoulder. She counted on her daughter to ask why. She knew her daughter well enough to be certain. She was right. Some arrangements do not need to announce themselves. They just need to be correctly structured and patiently held. And some people plan their care so precisely that it survives them, intact, waiting to be found by exactly the right person at exactly the right time. She knew her daughter would come looking. She made sure there was something worth finding.